There was a fiery face-off in the Supreme Court today. Chief Justice D.Y. Chandrachud told SBI's counsel Harish Salve that the bank cannot be selective in disclosing details. The Chief Justice also hit out at the Supreme Court Bar Association president for interference in the electoral bonds case. The top court has now ordered the SBI to fully disclose bond details by the 21st of March. Here's a blow-by-blow account of what went down in the top court today.
India's election season hits its peak, and so does the issue of electoral fundings. As the SBI's data release begins to uncover political finances by a range of corporate entities, from lottery to infrastructure, mining, telecom and more. The Supreme Court has instructed the bank not to pick and choose which details to disclose. The SBI has been directed to provide all information in full by March 21st, confirming there has been no withholding of information.
That SBI is required to make a complete disclosure of all details in its possession. Full stop. This, we clarify, will include would comprehend the alphanumeric number of and the serial number, if any, of the bonds which were purchased and redeemed. In order to fully effectuate the order and to obviate any controversy in the future, we direct that the Chairman and Managing Director of SBI shall file an affidavit on or before 5 p.m. on Wednesday, date daldo.
But we have one more day,
Thursday. Yes, certainly. 5 p.m. on Thursday, indicating that SBI has disclosed all details of the electoral bonds which were in its possession and custody, and that no details have been withheld from disclosure.
This order means that the SBI is now obligated to reveal purchase and redemption dates, as well as the names of the buyers and recipients. The denomination, alphanumeric and serial numbers of the bonds must be provided to the ECI, which will then publish them promptly on its website. The bench rejected the central government's claim of misuse of the order on the electoral bond scheme on social media.
We decide according to the Constitution.
Correct, Manoj.
We are governed by the rule of law. We are also the subject matter of comment on the social media and the press. But surely, as an institution, our shoulders are broad enough.
No, I'm saying, I'm not for a second.
Our court has an institutional role to play.
During Monday's hearing, when advocate Matthew Nedumpara attempted to intervene, the court reprimanded him for disrupting the legal proceedings.
Don't shout at me.
No, I'm very soft.
You are obstructing in the process of administration of justice.
My petition for suo motu that is pending. Whatever lordship want to do, that do only. No. I will not disturb lordship.
The court found that the president of Supreme Court Bar Association engaging in publicity-driven tactics when attempting to intervene.
Apart from being a senior counsel, you are the president of the SCBA.
Yeah.
You know the procedure. You have written a letter to me asking me to invoke my suo motu jurisdiction.
Yes, my lord.
No locus to mention
so
anything.
That I should not disturb lordship. We should not waste it honorable time, court's time. That's why.
Lord, only that. These are all publicity-oriented stunts. We will not permit it.
Whatever lordship feel better.
Mr. Agarwala, please keep it at that. I may have to say something more, which will be perhaps a little distasteful.
A heated hearing in the electoral bonds case.
After Supreme Court's clear and stern directions today, the State Bank of India will now have to disclose all information available with it regarding the electoral bonds, including the alphanumeric bond numbers. The Election Commission of India will then have to forthwith upload that data on its website. The SBI chairman will also have to file an affidavit before Supreme Court by March 21st, stating that no available information has been withheld. With camera person Sanjay Kumar from New Delhi, this is Shrishti Ojha, India Today.